Joining me now is Ben Crump, the attorney for the Martin family, and I'm with Natalie Jackson, co-counsel for the Martin family. Ben Crump, you've not been able to talk. You were, we thought, going to give a testimony. That didn't happen in the end. Now you are free to talk. I know you've not been heavily engaged in every day in the court, and so you have a more general view. But how do you feel the case has gone? Do you feel confident you've proven a case collectively that Trayvon Martin was murdered?
Well, Piers, you're right, and I'm glad to be free from being sequestered so I can now talk about the case. And I've been catching up throughout the day looking at different clips after it was determined the defense was not going to call me to testify. But I've said all along, Piers, if the jury follows the evidence, George Zimmerman will be held accountable of killing Trayvon Martin because nothing has changed. George Zimmerman followed, profiled, made a decision to get out of his car and chase Trayvon Martin. The 911 tape, clearly that objective evidence says that. The young lady he was talking to on the phone clearly says that. There's nothing to contradict that. And so who threw what first punch if they were struggling and rolling on the ground? Well, George Zimmerman started this confrontation. And so we can never get beyond Trayvon Martin just walking home and a strange man chasing him. Doesn't Trayvon Martin have the right to self-defense?
But here's the problem, Ben Crump, is that many people will have absolute sympathy with what you're saying. But at the same time, you say chase the evidence. And today it seemed to me there was a real shift by the state case in saying, look, we concede that Trayvon Martin was probably on top of George Zimmerman. Now, if you're that jury and you hear that U-turn on such a crucial piece of information, then regardless of what happened in the build-up, we don't actually know who may have started the fight. Regardless of that, you're now left with a jury that believe Trayvon was on top, and they are more likely, are they not, to assume that the voice crying out for help is the person underneath.
Piers, it has always been our contention that there was some struggle, and if Trayvon defended himself against a strange man who confronted him, he had every right to do so. But the cries for help, all of that is inconsequential when you think about who started this, who was the initial aggressor. Are you telling me if your child is walking home from 7-Eleven and some strange man come following him, that you don't want your child to try to defend himself when that person does not identify himself?
And Ben, and my answer to you there is absolutely not. But the problem you face is Florida law is very specific, and I've discussed this all week with various legal experts. It doesn't really matter what happened up to the moment that they're in this confrontation. What matters is, did George Zimmerman genuinely believe his life was in danger? If he did, he is allowed to use the gun by way of self-defense. So purely the letter of the law I'm talking about here, it is hard to see how the prosecution have proven that case against Zimmerman.
That's when I started screaming for help.
Well, I'll clearly say to you, Piers, we have to all acknowledge that if you had the dynamic turned around and you had Trayvon Martin kill George Zimmerman, the stand your ground argument wouldn't work for Trayvon Martin. And that's the trouble with this whole thing. It's so subjective when you think about it. But I believe in my heart that based on your child being chased by a grown man with a 9mm gun, and we hear that 911 tape, and then a couple of minutes later, he's shot in the heart and dead. I think those women on the jury have children, and they have to think that this could be my child, this could be anybody's child. And that's what's so troubling about this case, and that's why it's so emotional, Piers. People all over the country are saying, especially minority parents, what if this was my child? That's a horrible feeling to imagine your child do nothing wrong but walking home minding his business, and somebody gets out their car and chases him.
Let me turn to Natalie Jackson, because you've been in court, you've heard all this evidence. I mean, there clearly is going to be a lot of contention over whether the case for second-degree murder has been proven. However, many people believe that there is a much more compelling argument for manslaughter or aggravated assault. Could you see a situation where George Zimmerman is convicted of one of those lesser charges, and would that be satisfactory if you couldn't get a murder charge against him?
Well, what's satisfactory is what the jury decides in this case. We don't have a choice in that. We don't get to vote. I think that there's been a case made for both murder two and for manslaughter because manslaughter is a lesser included offense of, manslaughter is a lesser included offense of murder two. So that's why the jury will be given that option.
I mean, Ben Crump quite rightly feels very passionate about this. Many people feel very passionate about it. Emotions are running very high. But in the end, this jury will operate to Florida law and will be directed to do so. And, you know, it's very clear to me, talking to Florida judges, in particular Judge Alex and others who've got great experience there, that really it all comes down to George Zimmerman's state of mind when he pulled that trigger.
It comes down to whether or not his state of mind was reasonable to the average person. That would be, so that's really the crux of it. That's what the jury will decide. Were his actions reasonable? And the actions don't start in the middle of a struggle. They start from the beginning of him getting out of a car, armed with a 9mm, following and running after someone who's running away from him.
Natalie Jackson and Ben Crump, thank you both very much indeed for joining me.
Thank you.